Okay, so let's see, Jamie's story, that's a MTRP sentencing. All right, ma'am, you're Jamie Story, and this is cause number 23, DCCR 1546. Ms. Story was placed on probation February 25th of this year for the offense of theft of property with previous convictions, and that was enhanced to a third-degree felony. The sentence was a 10-year term in prison that was probated for 10 years. Motion to revoke was filed. We were here before, and Ms. Story pled true to all of the counts, 1 through 7. I've received the updated report. Have all of you had an opportunity to review that?
Yes, ma'am. I have.
And are there any additions or corrections?
None from the defendant.
Judge, my only thing that I would add, just for the court's recollection, and obviously I, of course, would not hold the court to this, we had some difficulty originally in getting her on probation. She volunteered a couple times, kind of based on her criminal history, made a stretch to make the offer. The court was inclined
Don't talk over her.
to go along with it based on some circumstances regarding her homelessness, etc. I do appreciate that she took responsibility for a motion. However, I have a note on my original plea papers that the state would be asking for primarily the max on the motion to revoke. But again, I know Ms. Holmes has an argument with some hard times that she's fallen on, and I'm not ignorant of that. I just want to let you know my position, what it was originally.
I appreciate that, Ms. Holmes.
Yes, Your Honor. I believe originally that was my concern with Ms. Story essentially having probation was her lack of resources, in which she continued when she was placed on probation in February of this year. That came to fruition. She originally was at her brother's home. That didn't work out, and then she went to go to Liberty with a friend, and there was pretty much lack of resources, lack of transportation, and she made the decision to then not contact because she got scared, and here we are. Your Honor, my main argument is that she has not been on probation long to get started. She never has gotten started. Now that she's been in custody, they visited with her at the jail to let her know what steps and what resources that they can provide, so she knows that she does have help if she does fall on these hard times, that is what probation is for. We are asking if she could get that opportunity to get started so that she can get the resources and the help. She states that she's been in contact with her mother, and her mother would be where she would reside if she's reinstated back on probation to get things back on track. I do see in the recommendations that probation stated if she is granted reinstatement to complete the cognitive track of the intermediate sanctions facility, in which I've gone over that with Ms. Story, and she is willing to do that to have an opportunity to get back on track with probation. Your Honor, we do understand she does have extensive criminal history, and this is not her first rodeo. However, we are asking, due to the severity of how long she can be sentenced to prison, that she at least have one more opportunity to start probation and get back on track and get the resources that she needs.
I don't have anything additional, Judge. I defer to what the court deems appropriate.
I mean, what's appropriate is for you to go to prison for 10 years, probably, with your history and the fact that you got this chance in the first place, right? I mean, probation has all the resources to help you, but they can't go find you and force you to take advantage of those resources. That's up to you. You've been on probation, you've been revoked on every probation you've been on. So the fact that we gave you a probation now and that I'm even considering leaving you on it is making me question my sanity, honestly. Do you have anything to say?
I'm just sorry for disrespecting y'all.
I mean, when you never show up, it's pretty much like you're just flipping us off, you know,
I understand.
for giving you an opportunity. And it's hard not to take it a little personal.
And everything, I'm sorry. I'm sorry for disrespecting y'all, and I will do it right this time.
What will you do different?
Everything.
Like what?
I'm gonna get me a job. I'm gonna go to work. I'm gonna go to probation. I'm gonna pay my fees. I'm gonna do everything that I'm asked to do.
Why didn't you do it before?
I didn't have a ride.
Well, but you could always call,
I understand.
right? You know, if you don't have a ride again, what happens?
I'm gonna get a phone call. I just had a granddaughter born, so.
All right, I'm going to do this. Going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. But I'm not going to do that today. I'm going to continue you on probation. I'm going to order you to enter and successfully complete the cognitive track of the ISF program. You will be on 0 tolerance. If I'm telling you, I mean, if you are back in here, I really am going to see all of this. I see everything every time. And there's not going to be negotiations. There's not going to be, let's give you less than the 10. You agreed to 10 years already. If you violate, it's 10 years in prison. And you can see your grandbaby when she's 5, 6, or 7 when you parole out. All right, so that's what's at stake, is a 10-year sentence, not some lesser, maybe just 2 because you couldn't find a ride. You agreed to it, it's all yours if you violate. Does that make sense? All right, go back with the bailiff. Good luck.
Here's the courtroom tug-of-war in full swing punishment versus empathy. What do you think should repeated offenders get another shot if their life circumstances are this rough?
Okay, are you Jordan Thomas?
Yes, ma'am.
And Mr. Thomas is charged in cause number 24, DCCR 0487, with sexual assault of a child, and in cause number 24, DCCR 2178, with aggravated assault with a deadly weapon. And Ms. Holmes filed a motion to reduce the bond. Is that in each of his cases?
And just the sexual assault.
Which is $100,000 in that case presently. And I know this was recently filed. Mr. Hoffpower, are you ready to proceed on that, or do you need time? All right, Ms. Holmes, do you intend to call your client?
Yes, sir. Yes,
Mr. Thomas, please raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You may proceed.
Thank you. Your name is Jordan Thomas, correct? And Mr. Thomas, how long have you been incarcerated at the Jefferson County Correctional Facility?
9 months.
9 months. And in those 9 months, has your bond been set at $100,000 for the offense of the sexual assault?
Yes, ma'am.
And has your family during that time tried to inquire about helping you make bail, but have been unable to due to the amount of it?
Yes, ma'am.
And do you have any property at this time or anything of value that you could sell that could arise to the amount to be able to bond out at $100,000? Okay, and have you all worked diligently within these 9 months to try to get that done, but have not been able to?
Yes, ma'am.
And are you asking the court to reduce your bond in an amount reasonable, and that you will abide by any conditions, and also whatever court appearances that you will be present, and that you will not be a flight risk?
Yes, ma'am.
So there was a bond forfeiture for non-appearance. That's why it's at $100,000 back in June of 2024. Why'd you miss your court date? Okay, you just didn't feel like getting up and coming? I mean, so she's asking me to reduce,
Transportation either, but
I can't hear you.
I had transportation. I take off for. I tried to come, but
Did you call anybody? And
I caught the bell. I caught the bell when I was coming in. Told them probably wouldn't make it. They told me to, turn myself in. So yeah. The day of court, they wanted me to turn myself in.
right.
after I missed the court there.
Okay, so when did you do that? Did you turn yourself in, or were you arrested?
I turned myself in
When?
December 19th.
So you decided between June and December, you would just kind of hang out and see if anybody caught you knowing there was a bond forfeiture?
I didn't know it was a bond for it.
Well, if you don't show up for court, you don't get to just not show up for court and not have any consequences and just chill out and wait till whenever, right? Mr. Hoffpower,
I don't have any questions, it's just arguing.
what's your position?
My position, in light of 17.15, danger to the community, just on the original charge, which we have here today on sexual assault, I think the bonds would be high sufficient because of due to the allegations and due to the danger of children in the community. Also, I want to add, obviously, the court knows there's another case that is before the court, and it is another serious, dangerous felony. It was committed while he was on bond and in bond forfeiture on his sexual assault case. So that he proved my point.
So
I know it's like similar actions, but it is.
The offense date on the aggravated assault with a deadly weapon is from August of 2024. And so, hold on. When was the bond forfeiture?
July.
No, you said June, July.
June of 2024.
I don't know why he wasn't arrested. He was arrested for, I don't know,
Why,
because the police interacted with him.
there should have been a forfeiture and a warrant on the other case at that time as well.
Yeah.
So while you were out on bond is when this new allegation allegedly happened. Let me look at the PC on that one as well real quick. There was a warrant. I don't think he was arrested. This shows Capia's return was from December, so that's when he turned himself in, probably on both of them.
I apologize if I presented something different.
No, I'm just saying, I don't think I think that's, hold on a second. I'm putting the PC.
Whoa, straight out the gate, 2 serious felony charges, one involving a child, and the other with a deadly weapon that's not just bad, that's catastrophic. In a courtroom, you can almost feel the tension thickening already.
Okay. Your motion's denied. Based on the fact that you were out on bond and allegedly committed this offense, which gives me some concern, which is the aggravated assault with a deadly weapon, and you missed your court date and really have no good reasons why or what you were doing other than potentially getting new cases, I'm going to leave your bond at $100,000. You can go back with the bailiff. We'll get an announcement at the next court date.
Yes, ma'am. Thank you.
Let me find it. Are you Nia Miller?
She's hard of hearing, Judge.
Okay, can you hear me?
Yes.
Okay, and are you Nia Miller?
Yes.
And will your client waive the formal reading of the indictment?
She will, Your Honor. It's actually a motion, Judge.
Oh, okay, of the motion, I'm sorry. Stand up, ma'am. Ms. Miller, in cause number 24-2227, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation January 14th of 2025 for the state jail felony offense of unauthorized use of a vehicle, and that was a 3-year deferred probation. Is that correct?
Yes.
It alleges that you violated your probation. Count 1 alleges that you failed to report as directed January 16th of 2025. And is that true or not true? Count 2 alleges that you did not provide verification of performing the community service hours. Is that true or not true? True. Count 3 alleges that you're behind in your court-assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Miller is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 1 year in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
I can't.
You cannot, for some amount of time. If you have, you should read that document. It'll explain that to you. If you have any questions about it, you can talk to Mr. Rojas to find out how long it lasts and what all that rules are. But you can read that document. It has the information.
And there it is, the one thing every judge hates. Missing court, no excuse, usually flies here. Once you skip a date, your credibility takes a hit that's almost impossible to recover from. What do you guys think? Should missing one date ruin someone's chance at bond?
All right, do you understand?
So with the time in, do I still have more time to do?
I don't know how much credit you get, but you will get credit for any time that you've been in custody that the law gives you the right to receive. They'll figure out that later today. The clerk will and send it over to the jail. Okay? You can go back with the bailiff.
Between June and December, he stayed out knowing he had a warrant, 6 months of freedom. He technically shouldn't have had judges see that as waving a red flag that screams flight risk. Let's be honest, would you trust him to come back next time? And boom, the prosecutor drops a legal bomb. Not only is the defendant accused of a violent act, but allegedly did it while out on bond. That's like telling the court, I can't be trusted outside these walls. Brutal move from the defense side to recover from this.